Hello, this is Dr. Ratcliff, and I'm happy to be here today with Dr. Audrey Miller, who's one of my close friends from graduate school and a clinical psychologist with expertise in forensic psychology. And you'll see my student Fola here with us too as an audience member. But I'm going to just turn this over to Dr. Miller, let you introduce yourself.
Well, thank you so much, Dr. Ratcliff, for inviting me. And this is something that we've done a few years now with this law and psych class, which is such a cool opportunity for you all. But this is a totally different format, as I'm sure it is for many of you, this virtual asynchronous thing. So please, in advance, forgive us any technical glitches or one thing I want to say, since we're doing this asynchronously, is that it sounds like Dr. Ratcliff invited any comments and questions in advance, but I'm here and I'll be here after this video and all of that. So if things arise in your head from our conversation today, please feel welcome to reach out to me and, any questions or that sort of thing.
I can provide the email at University of Houston then.
Yes. So my email is akmiller, AK like the letter K, Miller, MILLER 3 @UH.edu. So you're welcome to reach out to me there. And so as Dr. Ratcliff said, I'm a clinical psychologist by training. So my PhD is from Ohio University, I guess technically in psychology, but I did the clinical program, the American Psychological Association accredited clinical program where, your training is in applied issues, right? So I worked with children, adults, in health psychology. I worked a lot in violence against women, and marginalized groups was kind of my interest. And I actually ended up studying and doing research with the social psychologists. So even though I am trained in clinical psychology, my interests and my research interests in particular, and that's why Dr. Ratcliff and I collaborate, because we have a lot of mutual interests in violence against marginalized groups. So that was cool. But yeah, so I'm here to talk today a little bit about, and I actually work in a women gender sexuality studies program. So I have a lot of diverse interests, but today what I want to talk to you about is what is most relevant to you in this class right now, which is learning a little bit about this field and this professional area in clinical forensic psychology, which I know may be of interest to you, and it may be something that it's kind of hard to navigate or understand or know what the options are in, because I found the same thing. I had to do a lot of research to even get into the field. So let me just, what I want to do, I know Dr. Ratcliff has an excellent presentation on, I guess it's your chapter 10 maybe, on sort of mental health evaluation and kind of what forensic psychologists do, a little bit on criminal in particular. So kind of defining, for example, the difference between competency to stand trial evaluations and mental state at the time of the offense or insanity evaluations. So those are two biggies that you do in criminal forensic evaluation. And so I know that she did a preliminary good job, explaining sort of what the difference in those is. But if you'd like to talk more about any of those core concepts, I can answer questions now or as we go along. So I had a separate little slide presentation that I wanted to walk you through, just talking about issues of training, obtaining expertise, how you do that, and then also some practical issues about how you start to answer these questions and how you think about particular cases, and highlighting the Yates case in particular, which was one that got me interested in the field. So let me pause here for a second, see if there's any initial questions. If not, what I'm going to do is play that little introductory video that Dr. Ratcliff highlights in her slide presentation. Then I'm going to walk you through my slides. There's a longer video there. I'm not sure if we'll watch the whole thing, but it's a person who's sort of evaluating the psychological aspects of the Yates case, conjecturing, not somebody who was actually on the case, but somebody speaking to that effect. So let me do this. Let me play a little bit on the Yates case just to give you a brief overview of that case. Then we'll get started with the slides.
There were really two issues on the table. When I was
Your
called.
Can you all see?
One
Oh, no.
was she sane or insane at the time of the crimes? The other was, there were really two issues on the table when I was called in. Was she sane or insane at the time of the crimes? The other was, where does she fit with respect to the aggravating and mitigating factors for capital sentencing? With respect to the sanity question, I did all the things I typically do to try to get to the truth of the matter. And in this instance, it was actually fairly simple. It wasn't a complex case in that it was 100% clear with no reason whatsoever to doubt that this was a seriously mentally ill woman. And that's step one of the analysis. Does she have a mental disease or defect? Every state and the federal government require that step. And so she met that step. Step two is, if she was mentally ill, did that cause her not to know what she was doing? In other words, did she know she was killing humans? And did it cause her not to know it was wrong? Now, with respect to whether she knew what she was doing, there was never any question of that. She said always to everyone that she had killed her children, that she drowned her children, that she drowned each one of them as she named them. So there was never any belief on her part that these were vampires or werewolves or demons that she was killing.
Did you ask the question, did she know at the time, or when she was telling her friends afterwards, she was aware of what she had done?
At the time, of course.
So is there somebody that you were able to talk to that at the time she told them she knew they were her children?
No, the earliest statements she made, and now it's a little fuzzy because it's been 10 years or whatever. She made early statements to the police. She made a statement to the 911 operator. She made statements to the examiners, to her lawyers, which we're not privy to. But every statement that was recorded or transcribed and that we were able to learn about made it crystal clear that at the time she knew these were her children. So that was not in doubt. And she knew that drowning could harm them. So that issue, did she know what she was doing? 100% clear. Now then we get to the trickier issue. Did she know that what she was doing was wrong at the time? Now, in that respect, she didn't always say. You can interpret some things in more than one way. For example, when she calls 911 immediately, is that an indication that she knows it's wrong and that you call the police when something bad has happened? Or is that an indication she knew her kids were hurt, wanted to help? Or was it she was in distress? There are multiple interpretations of it. What there aren't multiple interpretations of are some of her own statements about that. So in her interviews with me and with other experts who asked her about these details, and not everyone does or records it, she said that she knew at the time of each child's drowning that it was against the law. She knew at the time of each child's drowning that it was against God's will. She knew at the time of each drowning that her husband and society would disapprove and that it was immoral. Now, state, including Texas, that means she would be responsible. I don't think it was a close call. Even though she was very, very sick, and even though because of her sickness, she thought that her committing this awful crime could help her children avoid the evils of the world and go to heaven on the fast track. Now, if the purpose of the evaluation is how do we display compassion to a sick mother who's killed her children, then the outcome, of course, should be that she goes to a hospital. But that's not what the law asks. the last this specific test. And under the test, she was legally responsible, which has the unfortunate name sane. So even people who are psychotic can be sane if they know what they're doing and know what's wrong.
Okay, so let me then pull up this share. So that's just sort of giving you sort of a brief overview of a case that we're going to talk about during my brief slide lecture, and then just to give you a little background. And but we'll talk about it in a little more detail, and just, you know, you can kind of think about those concepts and how these cases arise in real life, and what we're actually talking about as I present sort of, you know, the history of my interest in the field and training and expertise and that sort of thing. So let's get to that. Let me share that screen. Okay, can y'all see my slideshow?
Yes.
Okay, perfect. So yeah, we're just going to be talking about what the role of the expert is in a forensic mental health evaluation. So, as we'll talk about, this was sort of the area of my postdoctoral training. So it's kind of a specific, it's sort of a specific add-on to a career in clinical psychology, for example. So what are we going to be talking about today? Again, developing expertise, how you apply the expertise in terms of methods and work products. What do you actually do? What do you create? And then case examples and issues. Okay. So let's talk about how do you develop expertise in this field. So in order to, this is not always the case. So, for example, you can be a fact witness and be a licensed professional master's level counselor. It's not that your expertise is irrelevant to the courts if you are don't have a doctoral degree, okay? But in order to do the type of forensic evaluation where you are determining some of these psycholegal issues, competency to stand trial, mental state at the time of the offense, what the courts usually would require is that you have the highest, you know, training in that field of clinical psychology, which includes the issues of evaluations, mental health. How do you test people and understand what their psychologies are, what their mental states were at different times. So in the past, you know, currently, that sort of thing, which is relevant to different issues. So that's what you learn in your doctoral training. And I want to pause here for a second because, and again, I studied all this real closely. Like I knew kind of the area I was interested in. All I had to do was decide between law school and graduate school in psychology. Those were my two things. And so what I actually almost did when I went to graduate school was do a JD PhD program, which is like you do law school and your doctorate in psychology at the same time. And there were only like, I don't know, 3 or 5, not even that many, maybe 3 programs in the whole country who did that. When I was going in, that was, you know, I'm old, so whatever, that was a long time ago, but, and so maybe there's more now, but that was a really hot kind of new concept to combine law and psychology and to do actually these training programs where you could be fully credentialed in both fields. And I'm not going to go, I could talk about this all day, like I could write a memoir about this, but my mom's a psychologist, so I like knew what psychology was. And I had this thing where I wanted to be like super knowledgeable in psychology. Like I felt like if I did this JD PhD law psych program, like I was going to somehow be shortchanged in being like a broad thinking psychologist. So I wanted to kind of just do psychology and then specialize. And so that's what I did. I did a PhD program, a broad-based PhD program in clinical psychology, where I had all kinds of different, theoretical orientations in my training, therapy of various approaches, assessment. I took a lot of social psych classes and cognitive and, stats and all the things that would, help me fulfill that hope of being a broad-based psychologist. But then there it was in my clinical internship and my postdoc, I decided that I really did want to narrow in and get the training in these forensic evaluations. So and again, there weren't a lot of places to do that. So if you wanted to do actual forensic evaluations, there were only a handful of places in the country where you could be supervised doing forensic evaluations on clinical internship. And then again, on postdoc, it was like 3 to 5 places that were doing a postdoc in this area. So it was still very limited when I was, embarking on this area. But that's what I learned to do on internship. So, when you're doing your PhD or doctoral degree in psychology, it's usually at least 5 years to get all the way through your PhD and do your clinical training. And you have a 1-year internship that's kind of like doing a medical residency where you have to match online and all of that. And I chose to do that in forensic evaluation program. And then my postdoc, which your postdoc, I've highlighted here what is necessary credentialing, like to do testimony in court, you don't have to do a postdoc. That was just sort of because of the approach I took to having sort of a broad base. I wanted to make sure that I got formal forensic training, in my internship and postdoc. But that's sort of how I approached it. I mean, if right now you want to go do one of these JD, PhD programs, like it'll bother you if you're not a lawyer also, like all that, look into them. I'll talk to you about them. We can look at what's going on with them now. I actually worked in a program that is a PhD program in clinical psychology, but frames itself as a more forensic program. And I can talk to you, offline about, what my experiences were with that, whether that was a good model, which ways it was and was not. So if you all want to talk about training or have more specific questions, please feel free to reach out. Okay. But what you do after you're trained is you are licensed in a particular state as a psychologist. So I'm licensed in the state of Texas, but we have a lot better reciprocity and sharing going on right now since COVID. So there's a lot of things being done online and cross-state negotiations and all of that. Another thing that's optional, you don't really have to do, is you can be board certified in forensic psychology, as you can in several different areas of psychology. This was something I considered doing on postdoc. Never hurts when you're doing vanity things like testifying in court and things like that. But it just didn't, I was more interested in sort of the training than the credentialing. So I didn't do this piece. But what did I learn when I was in training? I learned competence to stand trial evaluations, which again, Dr. Ratcliff highlighted in your earlier slides. But can anybody broadly say, what does competence to stand trial mean? What is the expert evaluating in that case?
I guess I'll answer since I'm the only one here.
Yay, thank you.
It's the ability for like the defendant, if they're sane enough in the sense to like know what's going on, if they know what's like right from wrong.
Okay, so you're getting important point. I mean, there's a couple things we want to clarify. So right and wrong can get into issues of mental state at the time of the offense, right? So let's put that one on the table for a second. But what you were saying at first, that the defendant has to be able to fairly understand the charges against them, understand who everybody is standing in court around him, understand why he's there, understand and be able to communicate with his attorney and make rational decisions, not decisions that are like, I am going to win the lottery. And so, I can blow up the court system and, whatever delusions may be going on, right? We're talking about decisions that are actually, we would kind of consensually think are positive for that person's case, right? They have rights in court and they have to be able to utilize those rights, or they functionally do not have the rights, right? And so that's what competency is about. It's about, where is the defendant right now? Are they able to go into court and factually and rationally be aware of the circumstances, make decisions that are in their interest, and that sort of thing, okay? Now, this issue of right and wrong, okay, actually blends into the mental state question. Now, one big distinction between, let me advance here. Okay, so mental state at the time of the offense. The biggest distinction that you want to remember about competence and mental state at the time of the offense, or what we sometimes call sanity evaluations. Competence to stand trial is about standing trial. It's like, how you doing right now? Can you do your thing, right, in court? Mental state at the time of the events is about, wow, basically this psychological autopsy of what happened back then at that moment, right? And there are issues of both understanding the nature and quality of your actions. In other words, if I stab somebody, but I think I'm stabbing a pumpkin that I'm carving on Halloween because of my delusions and mental illness, I did not understand the nature and quality of my actions, okay? The other issue is this issue of rightness and wrongness, okay? And this was a really fuzzy and complicated, and that's why I love the Andrea Yates case. I love it in so many ways, both because it was like inspirational to me getting into the field, and because it has all these nuances about these psycholegal questions. So, the question of, did you know that what you were doing was wrong? And there's been sort of court-based, there's nuance about this. What do we mean by knowing it's wrong? Well, in the Yates case, clearly she knew she could be arrested. She called 911, she called the authorities. She knew she had done something wrong. And at the same time, she was firmly compelled that what she was doing was essentially carrying out, the religious divine will of God to, keep her kids in line and properly disciplined, and the things that God wanted in this fundamental sect that you'll hear she was a part of. So, this is a nuanced issue, right? This is people's real lives, these complicated issues, and we don't even have affirmative answers about, we're still working through the process of what does it mean to know right and wrong. These are, if you're a philosopher, you want to do therapy, philosophy, all those things, then go be a forensic psychologist, right? If you want to just think about stuff a lot, like, go think about these things. It's a super intriguing field. What is diminished capacity? So mental state at the time of the offense, or sanity defenses, has actually been outlawed in several states. It's not a viable defense in several states. In even fewer states, including the state that I did my postdoc training in, Washington State, do they have diminished capacity defenses. Diminished capacity is a little bit different from a insanity defense or mental state at the time of the offense defense. Basically, that's an affirmative defense. It says, okay, like based on the criteria we've already talked about, right? I didn't know what I was doing. I didn't know it was right or wrong, okay? Mental state at the time of the offense, or I'm sorry, diminished capacity is actually a diminishment of your charges themselves. Okay, so there's two criteria for being guilty of a crime. Okay, one is having done the act, and one is having the capacity of the mental state that was part of the act. So in other words, if you're charged with first-degree murder, not only did you kill somebody, that's the act, but you have to have had the intent to do so, which is the mens rea, okay? And diminished capacity means that a psychologist gets in there and says, oh, they really didn't have the capacity to form this level of intent. And so they weren't really able to meet both prongs of this crime. Does that make sense? Okay. Another type of, and I guess these little carrots maybe mean these are all kind of like criminal court type cases. So I did criminal and civil forensic evaluations. Spent much more time on criminal, that's the bread and butter, but I did do civil forensic evaluation also. So certification or transfer to adult court is when you're looking at juvenile or minors and looking at whether they qualify for being tried in adult courts. That's called a transfer to adult court. So, and then the stars or the asterisks are civil forensic evaluations. So one type of evaluation that I trained in is child custody or parenting evaluations, psychological injury or damages. So what does it mean to be injured psychologically harmed psychologically by somebody? And then how do you calculate damages for that? Civil commitment, which means that somebody is a danger to themselves or others, and therefore is involuntarily committed to a hospital or inpatient facility. And then dangerousness and risk can be both criminal issues, civil issues. So you could, for example, have a workplace that demands that their employee do a dangerousness or risk evaluation because they think they're gonna like blow up the place or something. And, you know, that could be a civil evaluation, or it could be somebody like the court's considering releasing from the hospital after an insanity disposition. And so they're trying to figure out if there's any risk to the community by releasing this person. So dangerous and risk are often add-ons to all sorts of different legal questions. You know, what can we expect from this person is basically the question there. So then what do you do? How do you apply these methods? You're always going to be reviewing records. If you're going to be a forensic psychologist and do these types of evaluations, you are a detective, basically. You're looking at all the archives so that you can, you know, form evaluations based on that collateral information about what has gone on here. You always interview the evaluee or the defendant or the parent or whatever. And, you know, that's an essential part of things. Sometimes people will refuse. Sometimes people are too ill to engage in an interview, but an interview is an absolutely necessary aspect. It is very important to my evaluation if somebody declines to engage in an interview, and that itself I'm evaluating, right? But you always want to attempt an interview. Sometimes it involves psychological testing. You know, one of the ways we use psychological testing, for example, is to understand whether people have psychotic or thought disorders that impair their ability to understand and properly or accurately perceive their circumstances. And so that could be relevant in one of these cases. And of course, observations. So we do that in a lot of ways. When I'm interviewing somebody, you learn how to observe what their mental status cues are. And so you use those in addition to what they're telling you. You actually compare them to each other. Somebody says, yeah, I feel like shit, right? And they're laughing and smiling and right? I'm going to observe that their affect is different from what they're communicating about their emotions. So observations is huge, not just during the interview, but, you know, if I'm evaluating parents for a potential parenting evaluation, I want to see them play with their kid. I want to see how they interact. I'm just going to sit back and watch that, right? Because that tells me so much. So again, mental status, how they're responding to you or whether they're responding to you, all these are relevant. Malingering, or whether they're dishonestly portraying themselves or their symptoms. Maybe they're trying to fake bad or trying to be sick in a way that they perceive will, will acquit them of some actual crime that they've engaged in. And I want to actually, that gives me the opportunity to touch again on Dr. Radcliffe's slides that did a good, very, job sort of overviewing some of these issues. I mean, one thing we want to remember is that people, especially on like drama TV, like portray these things are kind of hot things, right? Insanity defenses and blah, blah, blah. But my interest was always in working with seriously mentally ill people. That's how I got into this, because I was just really fascinated by mental illness and what it means for people's realities. The thing is, be aware you're not going to get an insanity acquittal from a crime unless you're a really bona fide sick person and several people agree on that and have testified and put their credentials on the line for that, right? So first of all, this defense is very rarely raised, and it's very even more rarely successful. And I think Dr. Ratcliffe's slides did a good job of giving an overview of that flavor. So remember, as we're talking about this is a very specific thing in experience that we're talking about. It's not like people are in and out of the court system pleading these things, okay? And again, other behavioral examples and other settings and contexts are always great to get a sense of who somebody is, right?
Quick question.
And so what, yeah.
How would you figure out if someone's faking their symptoms? Like, is it after a series of interviews, or is it just you can tell?
Very good. Yeah, that's a really good question. So if somebody is faking their symptoms or malingering their symptoms, that's what we call faking bad. Okay, so that means that they're enhancing or overstating or representing their symptoms, right? So maybe that can look like a lot of different things. And there are actually some structured instruments that you can give. I think actually Dr. Ratcliffe's slides may include a couple examples, like the MFAST is on there. I think maybe the TOM, test of memory malingering. The SIRS is a big one, structured interview of reported symptoms, which is a structured malingering evaluation. So you can actually, there are some structured protocols that are, that you can score and sort of use to get, and, it's always nice to use structured evaluations when you're working for the courts, because you can say, yeah, they scored this on this, and this is, relative to these norms, and you can kind of say that. But when you're doing this work, you actually don't need a SIRS. You can, your interview and observation is going to tell you everything you need to know, right? So there's this is a huge question. It's a great question, but we could do a whole thing on malingering, right? And how do you know if somebody's malingering? So just a couple bullet points on that. You're always looking for discrepancy in the self-report and the observation, right? So if what somebody is telling you about themselves is represented in their immediate behavior, in their behavior as it's reported in their records, all of that, that helps you corroborate a data point, right? But essentially with malingering, what we're saying is that somebody's self-report is not cannot be, is not veridical to reality. They're not being, accurate with you. And so how can you find that out? Well, you can find that out by seeing that somebody's behavior has been completely different, on a ward or in school or whatever than what they're portraying, right? Or you can, let's see, you can observe differences in, so if somebody tells me, I'm just going to give you a really specific thing. This is probably too much detail, but let me just give you like an example. If somebody tells me that they're hearing voices, which we know is, probably the, most prevalent hallucinatory experience you could have if you're psychotic, right? It's hearing voices. So somebody might report that, but the entire time during our interview, they are focused, reality-based, not attending to internal stimuli, which means that they're hearing voices, and you can see that they're hearing voices, right? That's going to be a discrepancy for me, right? So it's going to pursue my interest in figuring out, accounting for that discrepancy. Why is this person telling me they're hearing voices, but I'm not seeing any evidence of that during our interview? Does that make sense?
Yeah, I just want to ask you a question because
Yeah.
I know that when I ask, or when students ask your recommended course of training, you often say this PhD in psychology. Do you think your training as a clinical psychologist, and so you have worked with people who are really hearing voices, so that helps you determine when somebody isn't, maybe more than other types of training?
I mean, hey, I'm just going to tell you no, I'm just kidding. So yes, thank you. Like, that's the whole reason I did that shit. Like, I wanted to know how to do these things. I didn't want like the legal piece to skew my concentration on, great clinic, like, I did research in common factors in therapy, like how do you actually create alliances with people? Like I took all the like assessment classes, like child, adult, personality 1, 2, like, like I wanted to know all the tools, you know what I mean? And so, yeah, I like to think that, and actually, I was kind of an outcast when I was like interviewing for PhDs and stuff. Like, most of the people who got interviews at those postdocs were like, they did those JD PhD programs, or they had, done their internship in the Federal Bureau of Prisons, which is like prototypic thing you do on internship if you want to do forensic psychology and work in the prisons or whatever. That wasn't my thing. I love me working with some psychopaths, but like, I was interested in serious mental illness and the experience of that. And so I think it led me to understanding and maybe having an angle on forensic psychology that wasn't very typical, because some people did have more of a kind of bread and butter kind of like, black and white sort of understanding of some of these things. And I think my approach maybe gave me a more nuanced look at the population, for better or worse, but yeah, I've just always been interested in like the psychology aspects of it, and of course the legal aspects are interesting, but we all know that that's just social construction, and half of that's not done correctly. And if you're an idealist, then you've got to change the system anyway. So okay, so let me go ahead and just mention that a couple of the things that you do for work products are you complete a report where you talk about all your findings, what your database was, you say what you not only what you were able to include in your report, but what you tried to obtain and were not able to obtain. That sometimes is very telling. But your history, your interview observations, the history of the account of the person that they gave you about, if you're doing a mental state at the time evaluation, and then your psycholegal reasoning. So what you're recommending to the court in terms of how you see these psychological issues in this case. And so you'll pretty much always give a written report to that effect to the court. And many times the court is satisfied with that. I think during internship and postdoc, I didn't testify once about my reports. Like, they sometimes just serve their purpose, and the judge doesn't have any questions, and there you go. But if it's contested, if the court needs more information, et cetera, you may give testimony in court, where you would be, in the sense that we're talking about, where you're doing one of these evaluations, you would be certified as an expert witness by the court, rather than just a fact witness. Say you happen to come to court to testify what the defendant looked like when you happen to pass him walking down the street that day. That's a fact witness, okay? But when you're applying your expertise in these evaluations, you're certified as an expert witness for the court, okay? So, wanted to feel like I'm talking too much today. Let me give you this. Let me give you this overview. Do y'all feel like you could use a little bit more information about the Yates case? I know we did the very brief overview, but this guy kind of talks about the more the psychological aspects of it. So
that might be helpful. It might be helpful.
Yeah, let's do that. And let's see, stop share. Let me go to a different share real quick. And again, this case, am I on, or is my share on?
You're on.
Was the question, so it's you and not your PowerPoint?
Okay, it's me. Okay. So anyway, I was just going to say before I started this, like Andrea Yates, actually, their family, this all happened like a few blocks from where I grew up. And I grew up in this weird community where Russell Yates, the husband, was in the NASA space program. Like, that's the community I grew up in. So it was very personal, and it all happened as I was developing my professional interest in this area. So I just got really into this case. Like, I wrote about it for a lot of my papers in graduate school and things. But let me go ahead and play this. It's just an overview, and he's talking about this. He gives a little bit of an overview of her background. Sort of the parts that I just mentioned would go into your report, background, some information about her mental status, Andrea Yates's mental status, what actually occurred at the time, and how they think about the psycholegal issues, okay?
Welcome to my scientifically informed insider look at mental health topics. If you find this video to be interesting or helpful, please like it and subscribe to my channel. Hello, this is Dr. Grande. Today's question asks so I can analyze the mental health and personality factors that may be at work in the Andrea Yates case. Other questions here would be, what are religious delusions and how they fit into psychosis? Can I analyze the controversial testimony of Dr. Park Dietz in this case, and specifically the false testimony that may have led to Yates' conviction? Just a reminder, I'm not diagnosing anybody in this video, only speculating about what could be happening in a situation like this. So here I'll take a look at the background of Andrea Yates and the timeline of the crimes and the mental health factors. Starting with the back timeline, Andrea Yates was born on June 2, 1960 in Halls, Texas. She was the youngest of 5 children. As a teenager, she exhibited symptoms of depression, but but she did relatively well in school. In high school, for example, she was in the Honor Society, she was the class valedictorian, and she was the captain of the swim team. She graduated high school in 1982 and entered a nursing program. She would later work as a registered nurse for 8 years. She married Rusty Yates on April 17, 1993. They had been dating for 4 years. They were both 28 years old at the time they were married. Yates stopped working shortly after that, and they lived in Friendswood, Texas for a while. Then we see they have this trailer. They live in
I'm losing his audio on my end. Dr.
Same.
Are you too?
1997, Luke in 1999, and Mary in the year 2000. She also miscarried once in 1996.
Is that better?
After her first child was born, she had an hallucination where she envisioned she was using a knife to harm somebody. June 17, 1999, we see that Yates attempts to end her own life by overdosing on a medication called trazodone. This resulted in her first hospitalization. She was diagnosed at this time with major depressive disorder, single episode severe. Now, because of the limitations of her medical insurance, she was still symptomatic when she was released. She also discontinued taking the medication after her discharge from the hospital. Evidently, she started to engage in self-harming behaviors, like scratching bald patches on her scalp, picking sores, and scraping her arms. Now to June 2019, we had Yates attempts to end her life for a second time. The next day, July 21, we see she's hospitalized again. Here she's diagnosed with major depressive disorder, severe, recurrent with psychotic features. We also see a rule-out diagnosis. This was schizophrenia catatonic type. So this means that whoever diagnosed her believed she had major depressive disorder, but they weren't quite sure that it wasn't schizophrenia. That's what the rule-out is used for. So somebody treating her would look at that and know they had to rule out that other disorder if they wanted to gain some level of accuracy with the diagnosis. August 18, 1999, a psychiatrist named Dr. Starbranch warns Yates that giving birth again would likely lead to a psychotic depressive episode. January 20, 2000, Yates has what would be her last visit with Dr. Starbranch. Yates admits at that time she was not taking her medication. November 30, 2000, Yates gives birth to her daughter, Mary. Then we go to March 12, 2001. Yates' father dies. After this, we see she starts pulling out her own hair. She stops talking. She believed that there were spy cameras around the house watching her, and she believed television characters were telling her that she was a bad mother. Yates is hospitalized for a third time on March 31, 2001. On April 1st, Yates has her first appointment with Dr. Mohammed. He is almost catatonic. In 2001, he fills her bath with water. Later, she would admit that she had planned on committing the murders on that day. The next day, May 4, we see her fourth hospitalization. She's diagnosed with major depressive disorder, recurrent, severe, postpartum. June 18, 2001, she has her last appointment with Dr. Saeed. He discontinues antipsychotics and adjusts the levels of antidepressants. Allegedly, he told her to think positive thoughts. So kind of a dismissive comment there that has no basis in science. Moving now to
Wait, I want to hear that again.
Appointment with Dr. Saeed. He discontinues antipsychotics and adjusts the levels of antidepressants. Allegedly, he told her to think positive thoughts. So kind of a dismissive comment there that has no basis in science. Moving now to June 20, 2001. Yates caught of children by drowning them in her bathtub. She killed them one by one, posing their bodies on a bed after they died. The last one she killed was Noah, and she left him in the bathtub. She calls the police and then her husband. After the police arrived, Yates admitted she killed her children. August 9, 2001, the state of Texas seeks the death penalty. It may seem a bit surprising, but Harris County, Texas is known for executing prisoners. If this county were a state, it would only be behind Texas and Virginia in the number of executions since 1977. September 22, 2001, she is found mentally competent to stand trial. During the trial, prosecution and defense agreed that Yates was mentally ill. The question really came down to whether she was sane or insane. March 15, 2002, she is found guilty of 2 counts of capital murder. The jury deliberated less than 4 hours. 3 days later, she's sentenced to life in prison with the possibility of parole after 40 years. The jury only deliberates 35 minutes for this decision. Moving to January 6, 2005. On appeal, Yates' conviction is reversed. So what happened here is a mental health professional from California named Dr. Park Dietz had originally testified that there was an episode of the television show Law and Order that featured a crime remarkably similar to what happened with Yates. And the character in the show was acquitted for murder by reason of insanity. After Yates' original trial, Law and Order Criminal Intent did air an episode that was partially based on her case, but no episode like that had aired previously. It simply did not exist. So he testified to something that was 100% false. January 9, 2006, Yates is facing another trial. She enters a plea of not guilty by reason of insanity, the same plea she had entered for the first trial. July 26, 2006, after deliberating for 3 days, the jury finds Yates not guilty by reason of insanity. She was committed to a secure mental health facility. Moving now to the mental health and personality factors. So Andrea and Rusty Yates had unconventional religious beliefs, which were an area of focus during the members of a particular church in that area. Instead, they host Bible study groups in their home 3 nights a week. At the time they were married, the couple announced that they wanted to have as many kids as possible. Rusty may have applied a lot of pressure to Andrea to continue having children. Rusty believed in the teachings of a fundamentalist preacher named Michael Warniecki. This preacher believed that the forces of evil were always intensely threatening believers. He believed that parents were fully responsible for ensuring the salvation of their children, further proclaiming that parents would be better off ending their own lives than causing their children to burn in the fires of hell. Now, we see in the world of mental health that it's not unusual for fears to transfer into hallucinations and delusions. Anything that contains an element of danger can do this, like aliens, government agents, insects, disease. Again, almost anything dangerous can be converted and become part of the psychotic content. Religious beliefs that involve an element of danger can be transferred as well. And this is relatively common. It seems that this is what happened with Andrea. We see a good example in looking at the motive she offered for the murders. She said that her children were stumbling, disrespectful, and would not obey. Therefore, they were destined to go to hell. She also said they were marked by Satan. Therefore, the only way to save them was to kill them. She believed that when the state punished her for committing murder, Satan would be destroyed in that process. She continued to have hallucinations in jail. She said she saw satanic teddy bears and ducks. Although no teddy bear collection is complete without the satanic teddy bear, it is quite understandable why many people exclude this one from their collection. It's interesting, in my career, I've actually seen a number of instances where people believe that teddy bears, specifically, have supernatural powers and the ability to commit relatively complex crimes, like the ability to design weapons and pick locks, kind of like diver teddy bear. Often people with these beliefs are afraid to give the teddy bears away or lock them in a closet or whatever. It's like they're afraid to disrespect the teddy bears, to anger them even more, which I guess makes sense because with their advanced technical skills, the teddy bears could escape from a closet or some other locked container. It might be better for some people not to buy these teddy bears in the first place, so just say no to satanic teddy bears. Testifying as an expert witness for the prosecution, and he had been involved in his testimony. Dietz had a reputation of testifying as an expert witness for the prosecution, and he had been involved in an extraordinarily high number of high-profile cases. For example, Ted Kaczynski, Jeffrey Dahmer, O.J. Simpson, the Menendez brothers, and Susan Smith. The defense actually labeled Dietz a professional testifier, and he did not seem to be bothered by that. Dietz had repeatedly been criticized by mental health professionals as harsh and unforgiving toward mentally ill defendants, and he has been accused of presenting opinion as fact. Dietz stopped treating clients in 1981 or 1982. He couldn't remember which year. He said he had last seen a client who had postnatal depression in 1977, and he couldn't say for certain if he had ever seen somebody with postnatal depression who had psychotic features. As I mentioned before, he suggested that this fictitious episode of Law and Order may have given Yates the idea to commit the murders. We also see Dietz had an unusual conceptualization of insanity. He said that Yates was not insane because she knew what she was doing was wrong. He said he knew this because Yates expressed a belief that Satan had ordered her to kill her children, as opposed to believing that God had given the order. So if somebody believes that Satan orders them to commit a crime, they know right from wrong. But if they believe that God told them to do it, they do not know right from wrong. His statement is not supported by anything we know about psychosis. Essentially, he's saying that it's the client's belief about the origin of a command that matters. He's testified that Yates' second suicide attempt was deliberately more dramatic so that she could derive benefits from it, specifically moving into that new house. Rusty bought a house after this attempt. Evidence strongly supported, however, that she liked living in the bus. Now, as far as the Law and Order situation, when the mistake was uncovered, Dietz did admit it. But this really highlights how these types of mental health assessments in the context of trials are unreliable. With the false testimony, Yates was sentenced to life in prison. After the mistake was admitted, found not guilty by reason of insanity. Her whole life seemed to pivot on this one false statement by a mental health professional who may not have ever even seen a case like that before. The problem in the system is not about Dietz specifically. It's really about mental health experts testifying. Testimony is often light on facts and heavy on speculation. Interestingly, if someone did want to connect Yates' behavior to the media, the 1995 movie Seven with Morgan Freeman and Brad Pitt did seem to influence Yates. She said she was thinking of that movie the day she committed the homicides. She believed she had committed all of these 7 deadly sins. Now, it's not unusual in these types of trials to see competing theories from mental health experts. The defense in this case really put up a murky narrative that did indicate insanity, but they made it seem like they really didn't know exactly what was going on, which was actually correct. There was a lot of gray area in this case. The prosecution, however, with the help of Dietz, put forward a false yet clear narrative, and this is the one the jury believed. Sometimes it's not the accuracy as much as the cohesion of the story. Working with limited facts, mental health expert witnesses craft stories to connect the dots. Even if there are very few facts, they are still compelled to develop a complete story. It's frightening that the expert with the most complete story is automatically believed by the jury. Now, the jury that had convicted her said they were persuaded by the testimony of Dietz and by 3 other factors. They bought into Yates' own assertion that she was sinning at the time she killed. They said that the fact that she called the police meant that she was thinking clearly. Talk about setting a low bar for thinking clearly. Would they say that if someone was drunk and they called a cab, they were never drunk in the first place? The last reason was they thought that because Yates could describe what she did, she must have known exactly what she was doing. Undoubtedly, this jury had read the popular court pamphlet, How to Ridicule Logic and Convict, in 3 easy steps. What was going on in terms of pathology in this case? Well, Andrea Yates received just about every diagnosis related to psychosis that there is. Her father had depression, 2 of her siblings had depression, and another had bipolar. So it does make sense that the best guess that the mental health professionals had would have been major depressive disorder with psychotic features. Back when this case was going on, they would have referred to what they called postpartum depression. Now it's called peripartum onset. It's a specifier of major depressive disorder. It's called this because we know that 50% of major depressive episodes related to giving birth actually happen before the delivery. If a woman has a peripartum psychotic depressive episode, the chance that it will recur with a subsequent delivery is between 30 and 50%. This was such a tragic case. It seems as though Yates met the definition for legal insanity. This case really highlights how even people who are engaged in mental health treatment can fall through the cracks. Just about every professional that treated Yates recognized or suspected psychosis, and many tried to help her, but her own symptoms interfered with her receiving proper care. She didn't cooperate because of the symptoms, and this is a common situation that plays out every day in mental health treatment facilities. Now, some who have looked at this case have said that Yates should have been hospitalized for years, the very first time she presented with psychosis. But things like this are not unusual. If everybody who came into a psychiatric hospital with psychosis was hospitalized for years, the system would implode. It's really just impossible to provide that level of care to all the people who need it. It's kind of a sad state of affairs. From what I understand at the time of making this video, Yates is still in a mental hospital. She is eligible for a review each year to see if she can be released, but she has never sought release. So those are my thoughts on the Andrea Yates case. If you like this content, please consider supporting me on Patreon. I have the link for that in the description for this video. As always, I hope you found my analysis of this topic to be interesting. Thanks for watching.
Well, let me leave you all with the Andrea Yates case and just a couple thoughts about it. It's intriguing, as we said, not only because of these psycholegal questions, particularly whether what she knew, what she was doing was right or wrong, and how that conformed with the legal definitions. And clearly they saw that differently in the first and second trials. So just a really interesting case from every perspective, whether you're interested in, psychology and forensic clinical work, or social psychology, or, the legal system.